The brake lights flare behind you before you even realize how fast your own heartbeat has picked up. It's one of those ordinary afternoons that turns unfamiliar in seconds. The road is quiet, the radio is low, and then there's the unmistakable flash of red and blue in the rearview mirror. You pull over like you've done it 100 times in your head, but never in real life with everything actually counting. The officer walks up on the driver's side, one hand near the belt, eyes scanning before anything is said. There's a pause that feels longer than it should be. Then the question comes, calm but sharp enough to tighten the air inside the car. Are you armed right now? Have you ever actually been in a situation where an officer asked you that question while you were carrying or suspected you might be, and how did you respond in that exact moment when your mind went blank, but your mouth had to answer anyway? Whatever your answer is, that's the kind of thing people should be sharing in the comments, because what most armed citizens don't realize is that those first few seconds of interaction often shape everything that comes after. And if you stick with me through this, there's something deeper about how people unintentionally give up legal protections they didn't even know they had, especially when they're nervous, trying to be polite, or just trying to do the right thing under pressure. Now, layered on top of all of this is the conversation that has been spreading rapidly in legal and political circles about so-called one-gun-a-month laws and a supposed emergency-level attention from the U.S. Supreme Court that people are already misinterpreting in every direction imaginable. Some are calling it a sweeping nationwide change. Others are saying it signals a broader shift in how firearm regulations will be treated going forward, especially under the Second Amendment framework. But what matters in real life, on the ground, in traffic stops and front seat encounters with law enforcement, is not the headline itself, but what people believe it means while they're sitting behind the wheel with a loaded firearm and an officer standing just outside the window. Because belief can change behavior faster than law ever does. And behavior is what officers are watching long before any paperwork gets written. Let me take you into something most gun owners never really hear explained clearly, at least not in a way that connects law, psychology, and real-world pressure. When an officer approaches a vehicle, especially in states where firearm carry is common or where constitutional carry laws exist, the officer is not just listening to words. They are reading hesitation, eye movement, hand placement, and micro-pauses in speech. Not because they are trying to be dramatic, but because those details help them decide whether the situation is routine or something that needs to be controlled more carefully. Now imagine the driver who is legally carrying everything is lawful, permit in pocket or completely permitless depending on the state. The officer asks, "Do you have any weapons in the vehicle?" This is where things start to split into two very different outcomes, and neither one depends purely on legality. One driver says, "Yes, sir, I do have a concealed firearm. I have a permit. It's on my right side. I'll keep my hands visible." The other driver says, No. I don't think so. Why?" That second response, even if completely innocent, changes the tone in ways most people never anticipate. Because from the officer's perspective, uncertainty is often treated as higher risk than a clear yes or no. Not because the officer assumes wrongdoing, but because uncertainty introduces unpredictability. And unpredictability is what officers are trained to manage first. This is where the legal landscape people talk about online starts to collide with the lived reality of enforcement. Concepts like concealed carry permits, constitutional carry, and duty to inform laws vary dramatically across states. In some places, you are required to immediately disclose that you are carrying a firearm during a traffic stop. In others, there is no such legal obligation unless specifically asked. And then there are states where silence is legally allowed but socially misunderstood, which creates its own category of risk. Because legality and perception are not always aligned. Now, the reason discussions around one-gun-a-month laws have gained so much attention is not just about purchase limits. It's about how courts interpret the scope of regulatory authority under the Second Amendment, especially after recent major rulings that shifted how courts evaluate firearm restrictions. The idea that the Supreme Court could intervene in state-level restrictions, even temporarily or on emergency docket considerations, feeds into a larger narrative about nationwide consistency versus state-by-state experimentation. But here's the part that rarely gets discussed in public conversations. Even if a law changes on paper overnight, police encounters do not update at the same speed. Officers operate based on training bulletins, departmental updates, and practical enforcement guidelines that can lag behind legal developments. That gap is where confusion happens, and confusion is where armed encounters can escalate unnecessarily. I've seen scenarios described by law enforcement instructors where everything starts with something as simple as a glove compartment opening too fast or a driver reaching for registration without explaining what they're doing. The officer sees movement. The driver is just trying to be cooperative, but both are interpreting the same second differently. "Sir, don't reach for anything right now. I'm just getting my insurance." That moment right there is where adrenaline spikes on both sides. And if there is a firearm in the vehicle, even legally stored, even properly disclosed, the officer's decision-making becomes more deliberate. Not aggressive necessarily, but controlled. Sometimes that means asking the driver to step out. Sometimes it means temporarily securing the firearm while the stop is ongoing. Many gun owners misunderstand this part and assume it is a violation of rights, when in reality it is often framed legally as a safety procedure during an active detention, not a seizure of ownership. But perception matters again, because the driver may feel disarmed in a way that feels absolute, even when it is temporary and procedural. Now add passengers into the mix. A passenger carrying legally, perhaps in a different manner, perhaps in a different jurisdictional expectation, can complicate the officer's mental map of the vehicle. Multiple unknowns increase cognitive load, and officers are trained to reduce unknowns first before proceeding with routine enforcement like citations or warnings. And this is where nervousness becomes one of the most underestimated factors in these interactions. A nervous gun owner is not a suspicious gun owner by default, but nervousness often produces behaviors that resemble concealment or evasion. Excessive hand movement, over-explaining, reaching too quickly for documents, or avoiding direct answers because of fear of saying the wrong legal phrase. Officers don't expect perfection in wording, but they do respond strongly to behavior that suggests loss of control or uncertainty. The tragedy is that many lawful carriers think the safest thing they can do is say as little as possible. In reality, unclear silence often creates more attention than calm disclosure. Let's talk about consent searches for a moment, because this is another area where misunderstandings create long-term consequences. An officer may ask, "Do you mind if I take a look inside the vehicle?" And many drivers, especially those already nervous, will say yes without fully understanding that consent changes the legal framework of the interaction. Once consent is given, the boundaries shift in a way that is difficult to reverse in the moment. And yet refusal, when done calmly and respectfully, is also a protected right in many circumstances, though it can still lead to other lawful investigative steps depending on the situation. That tension between rights and perception is exactly where most people feel trapped during roadside encounters. Now, coming back to the broader legal conversation around firearm regulations and the ongoing scrutiny of restrictive laws like one-gun-a-month rules, what matters most is how quickly narratives spread versus how slowly law is actually implemented. Even when courts signal a shift, enforcement realities take time to stabilize. During that transition period, misunderstandings increase, especially among civilians who assume that a headline immediately changes what happens during a stop. But an officer on the roadside is not operating on headlines. They are operating on training, policy, and immediate risk assessment. And that brings me to something I want you to picture clearly. A driver is stopped at night. Interior light is dim. The officer asks if there are any firearms. The driver says yes, but tries to reach into the center console to retrieve something while explaining. The officer sees movement first, hears explanation second. Commands become sharper. The driver freezes, unsure whether to continue or stop. The firearm is legal, the permit is valid, but the situation is now emotionally elevated on both sides. This is not about bad intent. It is about timing. Timing is everything in these encounters. There are also interstate complications that many gun owners underestimate. Traveling with a firearm across state lines introduces a layer of legal complexity that includes transport laws, storage requirements, magazine restrictions in certain jurisdictions, and differing definitions of lawful carry. What is perfectly lawful in one state can become a technical violation in another within minutes of driving across a border. Officers on either side of that border may interpret behavior differently based on local law, even when the driver believes they are fully compliant under federal transport protections. And when people believe they are compliant but appear uncertain during a stop, that mismatch creates friction. Now, I want to touch something more subtle but extremely important because it comes up in real encounters more often than people admit. Self-defense narratives spoken too early during a stop. Some armed citizens trying to preempt confusion will start explaining hypothetical self-defense scenarios before the officer even asks. That often introduces unnecessary complexity into what should be a straightforward administrative interaction. Officers are not evaluating self-defense justification during a traffic stop unless there is an immediate incident. But once that topic is introduced prematurely, it can unintentionally shift the focus of the encounter. There is also a psychological layer here that most civilians don't consider. Officers are trained to maintain control of the conversational structure. When a driver starts rapidly over-explaining legal justification, it can create uncertainty about what is actually being communicated versus what is being preemptively defended. Now imagine combining all of this with the emotional weight of believing that major firearm laws are shifting at a national level, that courts are stepping in on controversial restrictions, and that enforcement may be inconsistent depending on jurisdiction. That environment creates a kind of informational pressure that follows people into their daily routines, especially those who carry regularly. The result is a driver who is technically lawful, fully compliant, but mentally overloaded. And that is exactly the condition where small mistakes happen. A hand moves too quickly. A sentence trails off. A response becomes unclear. A permission is given without understanding its consequences. A refusal is said too sharply and escalates tension unnecessarily. None of these are about guilt or innocence. They are about human behavior under stress. What many experienced firearms instructors try to teach, but what rarely sinks in until someone experiences it firsthand, is that the safest outcome in a police interaction involving a firearm is rarely about asserting rights aggressively or remaining completely silent. It is about controlled clarity, calm, direct answers, predictable movements, no surprises, because from the officer's perspective, surprises are the variable that everything else is built around. And yet, even with all this knowledge, real encounters still carry unpredictability. You cannot fully script how another person will interpret your behavior in a high-attention moment. That is why these interactions stay emotionally charged even for people who have done everything right. So when people talk about sweeping legal changes, Supreme Court involvement, or nationwide shifts in firearm regulation, what often gets lost is that the real-world experience of carrying a firearm does not reset with a court headline. It evolves slowly through training, policy updates, and thousands of individual human interactions between armed citizens and law enforcement officers who are both trying in their own way to get through the moment safely. And somewhere in that space between law and perception, between rights and reaction, between what is allowed and what is assumed, most people only realize the importance of preparation after they've already experienced the pressure of the stop itself. And once you've felt that pause, that silence outside the driver's window, that moment where a simple question about a firearm suddenly changes the entire weight of the conversation, you don't forget it.